honored to be here today with you to explain a topic that's near and dear to our heart, which is estate planning. Now, by way of background, Amro and I are both attorneys. We're partners and founders of a law firm called Muhammad Shamaila Tabahi, which is Illinois based. And we focus primarily on transactional law. Transactional law being estate planning, corporate, real estate transactions, and the myriad of other legal issues that can arise. In addition to running the firm, we have kind of a subsidiary of the firm, which is Islamic Wills USA, which it's a subsidiary, but we treat it as almost like a little bit of a nonprofit where our goal is to educate people on the estate, on Islamic estate planning. We provide quote unquote consulting services and mostly kind of educational seminars and things just to kind of help spread the word on how estate planning works. It can be a fairly complicated area, as you will kind of get a glimpse of today, just because we're focusing on two separate sides of the coin. On one side of the coin is the secular estate planning. On the other side of the coin, we have the Islamic estate planning. And you will see that there's little nuances and technicalities and issues relating to both and how to reconcile both. So again, as we delve into that, we're both lawyers, as I said, so we focus on providing legal services. Amro and I both have been practicing for about 10 years. I'm a graduate of Loyola undergrad and law school. Amro went to U of I Champaign for undergrad and then Indiana University for law school. So of course, as I said, because we're lawyers, we have to start out with a fairly lengthy disclaimer. So you guys don't have to read it as long as you can all say to yourselves that you all agree with it. So as long as you can agree with this disclaimer that you can't read, we'll be completely all right and good to go. But to be serious, this is just an informational seminar, right? Zoom jokes don't come along as good as they do in real life, but the disclaimer really boils down to one thing, which is that the information we're providing today is not specifically tailored to your particular circumstances. It's very general information, it's informational only, and we don't want you to go back and think that anything we say today constitutes legal advice on your particular matter. So just be mindful, this is general information, inshallah, for all of us to kind of get acclimated to the topic, to understand a little bit about our situation and what we can look out for in our own particular circumstances. But it's not the constant legal advice. I don't want you to go out and start providing, taking any steps that we mentioned today without at least talking to a lawyer specifically about your situation. So that's the real disclaimer. So overview of the presentation, we really have kind of four things that we want to focus on today. Discussing the basics of secular estate planning, right? So secular being both on the domestic as well as the state by state law. So estate planning is there's federal IRS and federal regulations that pertain to it, as well as Illinois specific laws that pertain to estate planning. So we kind of have to look at a little bit of both of those. The federal laws pertain mostly to federal estate tax, which we're not really going to get into because they don't apply for estates that are less than about $10 million. So presumably most of us don't have to worry too much about that. On the flip side, there's still Illinois rules and regulations and statutes that we have to comply with to ensure that our secular estate planning is up to date and enforceable. Second, once we talk a little bit about the secular side, we'll talk about the Islamic estate planning side. So again, two sides of the coin. We'll talk about both of those sides to kind of give you a general idea. And particularly, we'll discuss some hypotheticals. So again, I think a lot of estate planning is, it's nuanced, it's very much theoretical in nature until you actually see a couple of examples of somebody, let's say, passing away, given a certain circumstance or given a particular fact pattern, and then being able to see how that estate is divvied up, how that estate is handled after their death. That will actually explain or put a lot of these concepts into practice. And then finally, given the audience that we have today, the last slide, I want to focus a little bit on the Islamic estate planning as it pertains to converts, reverts. So we'll talk a little bit about that. And inshallah, that will be the gist of our presentation. Now, the first question, and I'll go first into the secular estate planning. The first question that I'm often asked as an estate planning lawyer is, when I talk about estate planning, typically I'll get this kind of deer in the headlights kind of look from people saying, well, I don't need this. I don't have an estate, right? So when you think about estate, this picture should tell you something. It's that, you know, people often think about, when they think about estate planning, they think about, you know, well, I don't have this vast estate. I don't have millions and millions of dollars. I just have a house, you know, a couple bank accounts, a car. So I don't really need estate planning. And that's actually wrong. So we have this notion of estate planning is only for rich people or people with huge estates, but in reality, it's for everyday Joes. It's for everyday people just like us who have maybe moderate to low assets. But the question is, what will happen in this world if I can't manage those assets? And what will happen in the next world if I don't properly take precautions relating to the Islamic components? That's kind of where the estate planning kicks in. So our focus is, when it comes to estate planning, we want to make sure that we are able to manage our affairs while we're alive, right? Let's say if you're alive but in the hospital and incapacitated or in a coma, what happens to your estate then? What happens to all the things that are, all the balls you have juggling in the air? Who can make decisions for you, etc.? And as well as after we pass away, what happens to all of my assets? Where do they go? Who do they go to? Does the state take them, right? Does the Illinois Treasury take them? The Department of Revenue take them? What happens? So when you go and talk to a lawyer, presumably when you think about estate planning or you talk about estate planning on a general kind of basis with an attorney, they'll mention or reference 4 particular documents. And this is kind of what forms the crux of a secular estate plan. There's going to be a last will and testament, a power of attorney for property, a power of attorney for healthcare, and a revocable living trust. And we'll talk a little bit about how those all can be different. But for purposes of today, just for the sake of giving you a general idea, a last will and testament is typically what you think about when you think about estate planning, right? So last will and testament is going to do a couple different things. One, it's going to identify who gets what type of property. So this is where one way, at least, to designate who's going to get the property. So so-and-so gets, you know, my diamond ring, so-and-so gets, you know, this bank account, so-and-so gets that bank account, all other property to my spouse, as an example, right? So the last will and testament will handle that. It'll also handle questions about guardianship. So if you have minor children, for example, who's going to have guardianship over the minor children if something were to happen to you and or your spouse, right? As long as one of you is living, obviously that parent kind of takes over as a de facto guardian just by nature of being a biological parent. But at the same time, if something happens to both of you at the same time, have you made the proper provisions to ensure that guardianship passes to whoever you'd like? So that's the last will and testament. Obviously, there's a couple other things you can throw into that, usually funeral and burial kind of requirements or things that preferences that you might have. Other things that you might want in terms of advice to people, advice to your heirs, successors, advice to your family members who are still living. People will often use that last will and testament as a way to kind of lay out any other thoughts or any other information that they want to share with their families. The power of attorney for property and the power of attorney for healthcare. These are in effect while you're living, but not after you pass away. So once you pass away, these power of attorneys do not take effect because they're no longer valid. But while you're living, whether you're incapacitated or not, these documents can help somebody make decisions for you. So common example, spouses will often have each other as the power of attorney for property and healthcare effective immediately. What that means is your wife or your spouse can make decisions related to property, and by property I mean financials, any financials really. They can make decisions for you even though you're alive, well, and sitting at home, right? Same thing with healthcare. They can make decisions for you, or obtain your medical records, things that only you could do otherwise. That power of attorney will authorize them to go and do that for you. So common ways that this kicks into effect. For elderly folks, sometimes the power of attorney for property and healthcare are very critical because they can't do any of the running around that they used to do when they were younger. They need somebody to, a son, a daughter, a spouse to do a lot of those things just to help them kind of manage their day-to-day. So power of attorney is a common way to take care of those obligations. And finally, we'll talk a little bit about revocable living trusts. A living trust is different than a last will, though it provides many of the same functions. It can't do the guardianship that we talked about that the last will does, but when it comes to distribution of property, it's a lot more flexible than the last will is. So the last will and testament, you can really just say, I want so-and-so property to so-and-so person, right? But the revocable living trust can actually spread it out over time. It's a separate document upon your passing. So it's the way to think about it is it's like a bucket, right? So you take your assets, you put them into a living trust, and then you dictate through the trust how you want those properties to be managed, how you want them to be distributed. Now, there's some Islamic limitations that we'll talk about with the living trust, but for purposes of the secular side, that's how the trust functions. While you're living, it's essentially a shadow of you, right? So it follows you. It's not separate from you, it's part of you. So it's not like you need to do a separate tax return or anything for it. Once you pass away, the revocable living trust takes its own form, and then it becomes its own entity that manages and owns, and manages assets for you for the benefit of your heirs. So again, there's Islamic components and things that we'll talk about that kind of tie into it, but that's generally speaking, when you go to talk to a lawyer for estate planning, this is the types of things that you'll be looking at in terms of executing these types of documents. So now let's jump to the other side of the coin, which is the estate planning in Islam. So one of the beauties of Islam is that it actually provides for us a way of life for everything. It's not just about praying, right? It's not just about praying and kind of these core obligations to God. It's also about how do we live our life in consistency with the sayings of Islam, sayings of the Prophet sallallahu alaihi wasallam. How do we live our life, right? So every little detail of our life there's an example for it. So it's not like we're supposed to make up how we do certain things or how we're supposed to govern ourselves or handle certain aspects of life, right? Islam gives us or prescribes us on how best to do everything. Estate planning is no different. So when you talk about estate planning, there's obligations written in, right? In the hadith, we'll see there's ayahs in the Quran that talk about how the heirs should receive their property and in what fractions they should receive their property. All of that is dictated through Islam. So at the core function, you want to always remember that it's every Muslim's obligation to not let 2 nights pass without writing a will about it, right? So this is a verified hadith of the Prophet. Essentially, it's emphasizing to us that we need to be mindful of the fact that this life is temporary. Our time could come at any time for us to pass on to meet our Creator. And we need to take the steps today, not tomorrow, right? Not more than 2 nights. We need to take action right now to ensure that your assets are accounted for, that there's proper provisions in place. Now, we'll talk a little bit about Surah Nisa, and that's where I'm going to kind of turn the mic over to Amro, but you'll see that there are specific shares assigned to specific persons. Now, there's a hierarchy, so to speak, of who gets what, and it's based on a system of who's living at the time of your passing. So if certain heirs are there, the nearer get more shares than the farther away, and more often than not, the nearer folks will cut off the shares of the more distant relatives. But the main thing that I have underlined here, a share made compulsory. So we'll talk a little bit about how the shares work in Islam. So if you have a chance, it's actually a very, very fascinating few ayahs, but essentially all of the rules of estate planning shares derive from a couple of verses of Surah Nisa, which is the 4th surah, the 4th chapter of the Quran, verses 11 and 12. They're fairly long ayahs, but they're really just fascinating to read because they're essentially like these very kind of long fractional sentences that dictate who gets what and what shares. So when we talk about an Islamic will, right? When we do an Islamic will or any will, Islam dictates for us how the money has to go out. So before we talk about shares of inheritance and who gets it, we first have to look at funeral expenses, right? So Islam prescribes for us a multi-step system where before you can get into who gets what, you have to first ensure that funeral expenses are paid off. Now, obviously, oftentimes, practically speaking, this money comes from the community or it comes from the immediate family, which is totally fine. But if, for example, somebody in the community doesn't step up or the immediate family doesn't have the funds to do the expenses for the funeral, that has to come out first and foremost from the estate. Next, we have debts. Now, this is obviously a very, very gray area, but debts being of two types. One is secular debts, and the other is Islamic debts. So when we talk about secular debts, what are we talking about? Right? If I borrowed $10,000 from so-and-so, regardless of whether it's written down, regardless of what the parameters might be, if I owe somebody $10,000, we need to make sure that we pay that off because we want to make sure that a debt does not stay over our head after we pass away. So there's kind of the debts that we have towards our Muslim brothers or anyone else that we lent or received money from. There's also, obviously, in the practical world, there's oftentimes mortgages, right? Loans, secured asset loans, like a car loan. How do we handle those, right? So Amr will talk a little bit about, when we go into the hypotheticals, we'll talk a little bit about those types of assets and how they get divvied up. But essentially speaking, in the way we live in this country, those are things that we have to account for as well. So the mortgage, technically, for example, we don't consider it due when somebody passes away. The mortgage company builds into its mode of business that if somebody passes away and somebody inherits the house, the mortgage follows the house. It's going to stay with the house, so the mortgage sticks. It doesn't stick to the person, it sticks to the property. And finally, sorry, one more point on the debts. There's kind of those secular debts, but there's also the Islamic debts. So for example, if you had fasts that you didn't make up while you were living, that you know you owed, for those there's a prescribed amount of money, if you aren't able to keep it, that you can pay to cover that Islamic, quote unquote, Islamic debt. There's other types of debt, zakat. If there's zakat that you know was owed, but you don't know about it or your family knows about it, they should take that off from the debt side before they even go into the details about the distributions to the heirs. And finally, we have this last pie, which designates the shares in Islam. Now, there's two types of shares. There's the wasiya, which you'll see at 33%, and there's a mirath, which is 67%. What are those two things? Wasiya is the discretionary 1/3. So the discretionary 1/3 can go to anyone you wish who's not already an Islamic heir. So the mirath refers to the Islamic shares to the Islamic heirs, right? So when we talk about who's an Islamic heir, typically we're talking about a spouse, parents, and children. So your spouse, your parents, your children. Those are your first line of heirs. And they're Islamic heirs in the sense that they're all going to have a prescribed share, which Amr will discuss. But before we can give them their Islamic shares, if you want, you don't have to, but if you wanted, you can dictate up to 1/3 of your estate to go to somebody else. So common example, somebody has an uncle who took care of them here in the US, who really treated them like a son, made sure that they got through their education, right? Help pay for education, help pay for living expenses. So what you could do, for example, is designate 1/3 of your estate for your uncle, because your uncle is not going to be, most likely not going to be your Islamic heir. He could be technically if your whole entire family were to pass away, but more often than not, that uncle is not going to be somebody who gets an Islamic share. So you could use the 33% to cover that kind of gift, right? So you can think of it as a gift up to 1/3. And then the mirath, the remaining 67%, would be prescribed to the Islamic shares. Now, there's a couple of points to keep in mind with the wasiya. There's a famous hadith that discusses the wasiya provision where somebody came to the Prophet and asked, can I give so-and-so this much of my property? And the Prophet ﷺ said no. Then they asked, can I give 50%? And they said no. And then the Prophet finally said, you can give up to 1/3, but even that is too much. And that was to somebody who was not an Islamic heir. So we have that kind of phrase of up to 1/3, but even 1/3 could be too much given your particular circumstances. There's also a common premise that it's better to leave your family wealthy than to leave them begging on the street. So that's why we don't have a provision necessarily where all of our shares or all of our assets are distributed to a nonprofit, for example. We can designate up to 1/3 for that nonprofit if the circumstances are right. But the reason we don't do more than that is because we have the Islamic share system where we want to make sure our wealth passes on to our families and that our families are well taken care of. So in a nutshell, this is the requirements of an Islamic will in terms of the hierarchy of payments. I'm going to turn it over to Amro to kind of jump into the fixed distributions that we discussed in Surah Nisa and how those shares come about.
Okay, great. Assalamu alaikum, everyone. Furkan, can you hear me? Am I good?
Yep, you're good to go.
Okay, great. So I'm going to start this part of the presentation by going through the Quranic ayahs that Furkan mentioned earlier in Surah Nisa because they do make up the foundation of the Islamic inheritance laws. So I'm not going to read them verbatim, but we are going to have them on the screen. When we start with the verse 11 of Surah Nisa for Furkan. Okay, there it is. I want to first draw your attention to this. I believe it's the sixth line where it mentions that everything that precedes it, when we're talking about the distributions, it's after the debts are paid. So if you remember the slide earlier where Furkan was differentiating wasiya from mirath, well, all that comes after the debts are paid. And then you'll see in another ayah, it talks about even after the wasiya is paid. So everything I'm going to discuss moving forward, I'm talking about the mirath and only the mirath, nothing else. So right here in verse 11 of Surah Nisa, you'll see that it starts out by saying the male child receives twice as much as the female child. A lot of people wonder where this comes from. It comes from this ayah. And the next point under this ayah is if somebody has two daughters or more, and the assumption is no sons, then they get 2/3. If somebody has only one daughter and no sons when they pass away, that daughter gets 1/2. And then this ayah also states that each of your parents, when you pass away, are entitled to 1/6 if you had children. This is important. I want to draw your attention to this because you're going to see, look at the ayah closely. You'll see that it has things like 1/3, 2/3, 1/2. Well, if I ask you, okay, what fraction do the children get? If you look closely, you'll see that there's no answer there. And we're going to talk about it more on the next slide. But for now, that's what 411 gives us. 412 talks about what the spouses get from each other. So if you don't have children, so you're a woman who doesn't have children, but you're married, your husband is entitled to 1/2 of your estate. If you do have children, your husband is to receive 1/4. If you're a man, your wife would be entitled to 1/4 if you have no children, 1/8 otherwise. So if you have children, your wife would receive 1/8. And then the rest of the ayah I want to just point out, it says siblings in this translation. Most scholars, or I believe all scholars, agree that it's talking about half siblings, and that's a topic we're not going to discuss today. When it comes to siblings, it's actually the next ayah that's going to talk about how your siblings will inherit. That's ayah 176. In this, the Prophet ﷺ, or sorry, uh, the Quran directs that if you don't have any ascendants or descendants, that means no parents and no children. If you have one sister, your sister receives 1/2. If you have two or more sisters, they share in 2/3. If you remember from 411, it mirrors the inheritance that your daughters would receive if you had daughters. If you have brothers, however, all that gets thrown out the window, and the brothers and sisters share in the inheritance, where the brother receives twice as much as the sister. Again, note that in this case, there's no fraction. So how does this work? Why do some things have fractions and others it's just twice as much as the other? How does Islamic inheritance work? How do we put this together? The next slide will explain. So in this table, notice that a husband is going to get 1/4 or 1/2. That's just how a husband inherits. There is no other numbers there. What we do when you pass away is we identify your living relatives first who are entitled to a fraction. So we're going to have an example later. But really quickly now, if you were to pass away with one husband and let's say 10 children, five sons, five daughters, and no parents, you can just look at this and say, okay, the only heir here is the husband. The husband is going to get one fourth. And then the sons and daughters are going to share three fourths. So if you have 10 kids, they're going to get less money than if you only had two kids. Your husband doesn't get more or less. It doesn't matter how many children you have, as long as you have at least one child. Your husband's just going to get one fourth. And that's why if you hear Islamic scholars talk about your different types of heirs, you'll often hear them divide heirs into two categories: the Quranic heirs or the prescribed heirs. That's one category. The other category is the residuary heirs. So we calculate the fractions first, and then whatever's left over, that's what your children receive if you have children. If you have no children, then and you have no parents, let's say, then that residuary is what your siblings would receive. And we will have an example later to drive that home. On the next slide. Okay, so here are the residuary heirs. Now, this is an example. When you pass away, there will only be one class of residuary heirs for you. It's going to be your survivors or our survivors' job to find out what class that is. So if you have children, then if you have children and one of them is male, then your children will be the residuary heirs. If you have no sons, and let's say no grandsons to keep this simple, but you have paternal ascendants, that's like a father, your father will be the residuary heir. So if you pass away with, this is actually an exception to the rule, but just to keep it simple from what I've told you now, if you were to pass away with only a mother and a father, and you just looked at the rules up to now, uh, your mother would inherit one sixth, and your father, because he's a residuary heir, would inherit the remainder. That actually, this is an exception to one of the rules because of the that we learn in a hadith where the mother would actually inherit more than just the one sixth. But I do want you to know that that's the general concept. By the way, I want to do a disclaimer here. Everything we're discussing here is to give you an idea of how Islamic inheritance works. You are not going to walk away an expert out of this lecture because uh, we would be here minimum 4 hours to get you to a point where you can go through most of the exceptions that do exist under Islamic law. Okay, so let's say you don't have a father, you don't have any sons or grandsons, then your siblings would inherit if you have at least one brother. If you don't have any brothers, even if you have sisters, if you don't have any brothers though, then your paternal uncles and their descendants would share in the residuary inheritance. And again, if you don't know what residuary means everything left over after you give the people who are entitled to a fraction of your estate. Okay, so here we have an example. Now, we have a family unit, and I believe, yes, the husband's going to pass away in this case, but we have the family unit. I want to point out the ages don't matter except for Islamic planning, but they might matter for your secular planning. And that's something that if we have time, I will talk about at the end. Um, so you have a husband, two sons, two daughters, and both sides have siblings alive. Um, Now, what considerations are you going to have? So, if you have a house that you own jointly with your husband, then when you pass away, by operation of Illinois law, your husband will retain entire ownership of it. It doesn't matter what your will says. This is very important because it often frustrates the Islamic purpose. On the flip side, I will talk about, or Furkan will talk about at the end, uh, potential headaches if we will try to uh, adhere very strictly to the Islamic percentages because you might not want your spouse's home being owned by your entire family, and now your spouse only owns one fourth of the house. So, uh, but just know that house, it doesn't matter what we put in the will, it's going to transfer to your spouse on your passing. Okay, husband's 401k, spouse is listed as a beneficiary. Similar to the before point, it doesn't matter what your will says. Your spouse will receive 100% of the 401k if your spouse survives you. Same with the IRA. We have a wife's IRA. If the wife passes away, the husband will receive it. Um, and yeah, the practice pointer, I'll wait till the next slide because I know in the next slide we have other different fact patterns. A personal bank account in the husband's name only has 50K in it. So if the husband passes away, now your will comes into play because there's no beneficiary named on the account. By the way, a lot of people don't know this. You can name a beneficiary on the bank account, and that would actually supersede the will. So if you don't name a beneficiary on the account, in this case the husband hasn't, when he passes away, if he has an Islamic will, it will be given, the cash will be given to the beneficiaries through the Islamic percentages. And then two joint bank accounts, similar to the joint house. Doesn't matter what the will says, the survivor will retain ownership. Okay.
Now, I wanted to stay on this slide. It was kind of my example for the secular side of the estate planning. So the thing to keep in mind for everyone here is that when we talk about secular estate planning, we have a couple of different goals. Primarily, we want to avoid this dungeon of that we've all heard of, which is probate court. No one wants to go into probate court, right? So the way to do that, and by the way, sorry, I kept having that husband kind of flying off the screen. I'm not very good with the images in the animation, so this I was pretty proud of the fact that I was able to put this animation in. So, anyways, the point to keep in mind for the secular side of the estate planning is the first thing you want to do is take stock of all of your assets, right? So this is a pretty standard, moderate family. You might have a house, right? A 401k, retirement accounts, a personal bank account, joint bank accounts. You want to make sure first and foremost, what assets do I have, right? What assets do I have? What liabilities do I have? So before you even get into any kind of estate planning, the first thing that your lawyer is going to make you do, even if you go to a lawyer, is fill out a asset disclosure sheet, right? An asset and liability worksheet. So we understand exactly what assets are in play. And then we kind of focus on asset by asset. How's it going to pass if something happens to you? So the house, if you have a house or a condo or what have you, there's a deed. You want to see how the deed has been executed. If you have that joint title with the right of survivorship, or you have you and your wife, let's say you and your spouse's name both on the deed, as long as one of you passes away only, the house goes to the survivor 100%, like Amro mentioned. Obviously, in the scenario that both of the spouses pass away together or simultaneously, it creates an issue where there's no more designation for an heir. It has to pass through your will and it has to go through probate. So that's going to be something that always is of a challenge. One of the most common ways we can kind of work around that is we can do what's called the transfer on death instrument for a home or a real estate property. And all that does, it says that if both of us pass away, the two joint title owners, then we want the house to pass to so-and-so. Again, when you think about that coin, there's two sides of the coin. I'm kind of focusing on the secular side only for right now, but you can designate who's going to get what through that transfer on death instrument. 401k, same thing with the beneficiaries. You can list out who the beneficiaries would be. Same thing with the IRA, same thing with the bank accounts. So I think we kind of covered that side. On the secular side, Amor, is there anything else?
Well, the next slide has the fact twists.
Yep.
But
Kind
yeah,
of on this,
I
on this
think
base.
we're covered.
Okay. So now, guys, just to make it a little more fun and more confusing, I have some fact twists here that I threw in there. That if the house was titled to the husband only, if the children were really, really young, or we have in this situation, I put a couple of adult kids and a couple of minor kids. Amro, can you touch on maybe guardianship as well as assets left to children? And then what if there's $2 million in that husband's bank account, right? We have 50,000 versus $2 million. And then what if I want my children to inherit at the age of 25 and not when they turn 18 or 21? What if my husband and wife pass away together in a tragic car wreck? So again, just some twists and hypotheticals to think about as we talk about distribution of assets in a secular, primarily in a secular perspective.
Right, absolutely. And this is the primary reason, and what I talk to people about when they tell me, why don't I just print a will off the internet and sign it there? Why should I see a lawyer? Well, you have to know not just what the will says, but also the legal consequences, and you have to know the right questions to ask. And I think these are all very good questions. So to go through them one by one, I will talk about first the the consequences of each, and then I will talk about potential planning and considerations that you guys might want to have with your attorney uh, regarding the potential issues these cause. Okay, so first off, what if the house was only in the husband's name? Well, in that case, it will pass through probate, so the court's going to get involved to make sure the house goes pursuant to the will that you draft. And if you just use a stock Islamic wills template, that means that the wife is only going to receive 1/8 of that house, and likely is going to be forced to sell it if the other heirs don't allow her to live there. Now, that may not be what your intentions are. I will say from the Islamic side of things, that gets a little fuzzy as well. But do know that if the house was just in the husband's name, and by operation of law, the wife would only receive 1/8 of it. Um, I should point out that Illinois and perhaps every state, I know majority, they have wife or spousal rights where the spouse could claim a homestead exemption on the home. In Illinois, it's $15,000. In New York, I believe it's 100 or $200,000 worth of value in the house. And the wife does have rights to revoke the will if she feels she's not getting enough. So ignoring again those complications, your lawyer would discuss them with you. Just know that don't print the will off the internet and sign it. It might not have the consequences that you want. Number two, what if the children are really young? A very good question. So let's say you have $100,000 in your account, and then your child's supposed to inherit $30,000. Is your 14-year-old going to get $30,000 from you? Well, it will go to their guardian, and their guardian likely will have to set up a open guardianship estate, or at the very least, open up a guardianship account, like an UTMA account, if you guys have heard of that, and hold the money for the children there. And to prevent guardians from misusing the money, uh, guardians often have to get court approval in order to access that money for the benefit of the child. Um, Now, I will skip the next questions because the fourth question is related. Can you prevent your 14-year-old from receiving all of this money or receiving it when they reach the age of 18 or 21? And I will say absolutely. Very common instrument is the trust that Furkan mentioned. And within the trust, what we often do is we say, any portion that's going to be given to a child of mine, instead, let the trustee hold it in trust for the child until they reach the age of 25. However, the trustee shall pay for all of the school expenses or medical expenses or anything the trustee thinks is for the benefit of the child. That way, the child, uh, they have to go to the trustee to get access to this money. They can't blow it because they're trying to impress their 18-year-old friends, in the dorm rooms in college, right? They can't go get an $80,000 car or $200,000 car with your inheritance, at least not without the trustee's permission. But once they reach the age of 25, then they can receive the funds. Now, I will say under secular law, you could choose whatever age you like. Under Islamic law, there is the Islamic consideration that you're actually not allowed to withhold money uh, from any beneficiary like this. Now we've spoken to muftis about it. The super, I feel like we got the same response. They always laugh. Like the super strict rule, really, it's at puberty, is when children are supposed to receive it. However, we know that children are not the age of maturity in this case, at puberty. So very often they do allow us to pick ages like 18, 21, 25. But I will say there's a difference of opinion Islamically whether you can wait all the way until 25 or you have to give it to them by 21. But there is that maturity requirement. You can't just withhold it forever. The third question, what if husband's bank account has $2 million in it? Now, I understand why Furkan put this in the slide. In the earlier slide, we talked about a husband having $50,000 in a bank account. I will say, if you pass away with less than $100,000 to your name and not designated to a beneficiary, so IRAs don't count because you could name a beneficiary. Your joint assets don't count because the beneficiary is, of course, your joint asset holder, usually your spouse. But if you pass away with more than $100,000 to your name, your family cannot go to a bank and say, well, here's a death certificate, here's the will. mom deserves this much and, my brother deserves that much. No, the bank will say, go to court. You have more than $100,000 to your name, get a court order approving the will, and then we'll give the money to the executor under the will, and the executor can do what they want with it. So it gets put within the jurisdiction of the court. If it's less than $100,000, like in our initial example, is only $50,000, your family could do a very cheap instrument. It's called a small state affidavit. In fact, a lot of people, they do it on their own for free. They tell the bank, Dad had less than $100,000 to his name. The only thing he had was this one bank account for less than less than 100,000. It's $50,000. The bank will say, okay, I see the death certificate. I see the will. The will says here are the beneficiaries. The bank actually cuts the checks directly to the beneficiaries under the will. So one common strategy is people make an effort to die with less than $100,000 to their name, so that their family doesn't have to go to court in order to get access to the assets. And now, what if husband and wife pass away together in a tragic car crash? That is a huge issue. A lot of times, what happens is in your wills, and I will say that the muftis that we've talked to have allowed this. In your wills, you would name your spouse to receive 100% of the assets and say, my spouse will take care of everything. Well, what if you guys are in a tragic car accident and one of you passes away at 4 p.m. and the other person passes away at 5 p.m.? Well, the second spouse is receiving all of the entire estate. Then when that second spouse passes away, it's going to be her mom, her dad, her brothers, potentially if there are no children, that are going to be inheriting, whereas let's say the husband passed away first, the husband's family will get nothing. So it's always a consideration we have when drafting our wills, to plan for the possibility of a simultaneous death. What should happen in that case?
But the main point I
Now,
wanted to drive home is that all these beneficiary accounts, it's a problematic circumstance because now that beneficiary is not alive either. If there isn't any second line or contingent beneficiary, you're ending up in probate court, which is obviously one of the big considerations. People don't want to be, they don't want to end up there. But if the simultaneous death happens, then your will has, everything to my spouse, for example. That would be that's the scenario where that's really a problem.
yeah, absolutely. I did have a point that I forgot about, so we will just go to the next slide. Okay, so here we do have a real life example of how the Islamic distribution should work. So we have a mother, a father, and that man in the middle is passing away. That's going to be the red X you're going to see on your screen. And then he leaves behind a wife and two kids. So if you guys, oh, Furkan gave it away. All right, if you guys notice how it's calculated, notice that the mother and father, it's 1/6, 1/6, because that's what the Quran prescribes for them. The wife, 1/8. We calculate those numbers first. We can't know what the children receive until we calculate who survived the husband and what shares the Quran prescribed to them. Now, the Quran, what shares did they prescribe to the kids? Nothing. There's no fraction for them. So that's how we leave them at the end. So after we calculate the 1/6, 1/6, 1/8, we take what's left over, called the residuary, and give it to the kids. Because there's one boy and one girl, you'll see that the fraction for the boy is twice as much as the fraction for a girl. Very often, you'll see in the wills that we do, you get very funky fractions when it comes to the children. But the mother and father and spouse, it's never a funky fraction. It's 1/6, 1/8, 1/4. It's always exactly what the Quran prescribed. So that is it for my portion.
So guys, again, this kind of content can cover, semesters and semesters of lecture time, but really we're trying to condense it. I wanted to just give one kind of secular example, focus on the secular issues, one example from the Islamic side and who technically is the Islamic heirs to your estate, and kind of break it down in two separate components. Now that interplay between the two sets of laws is where it gets a little more complicated. A lot more, is required in that front. And typically we always recommend open dialogue between spouses, families, so that everyone understands, what the Islamic component requires and why, and how it would play out in the in the inevitable situation where people are passing away. So I wanted to spend just a little time, and we kind of had it structured for an hour, so I have a couple minutes left. I wanted to kind of focus on reverts, converts, who there's a hadith in Sahih Bukhari, very well known, very well kind of taken by all scholars. It's that there's, it's a saying that a Muslim shall not inherit from a non-Muslim, and a non-Muslim shall not inherit from a Muslim. So when we talk about those Islamic shares, right, not the wasiya, but the Islamic shares, that mirath, if one of those family members is not Muslim, they do not get that share. So if, let's say, you have a parent who's alive and you have a family that's Muslim and a parent who's alive who's not Muslim, under this hadith, we see that that parent technically does not get their share. Now, there's some difference of opinion here, so I wanted to kind of flag that. But as a general principle, there's a couple things that are agreed upon amongst essentially all scholars. And that is that before you even get into the mirath, remember that you have that 1/3 wasiya, right? So if, let's say, you had a parent who has, who's not Muslim, but you still want to give a share to, because obviously they're your parents, you could designate up to 1/3 to that non-Muslim person, even though they're technically otherwise would have been an Islamic heir if they were Muslim. So there's no dispute there. Everyone agrees that 1/3 can be utilized as you see fit to whomever you want who's not already an Islamic heir. So you can't use that 1/3 to, double up on your daughter's share, for example, because she is already going to be an Islamic heir, but you can use that 1/3 on somebody who's not an Islamic share, i.e. somebody who, let's say, is not Muslim, who you're related to. Gifts in life. So another common way that people can get around this is that, let's say, if you have a lot of jewelry, you can give the jewelry, for example, as a present day gift, because when we talk about the Islamic estate, we're talking about what you own at the time of your passing. So it's not what you own today, right? So gifts can be given without any consideration to the Islamic rules of inheritance, because it falls outside the rules of inheritance. So there's a caveat there is you can't do that kind of gift if it's going to create injustice or reasonably result in some kind of dispute within siblings or within the family. So the goal isn't to give it all to so-and-so and say, well, too bad to my family or my heirs, because this is something that's outside the shares, I'm giving it as a gift. On the same token, if you wanted to give some to a non-Muslim person, for example, let's say jewelry, all my jewelry, I want to give it right now to my mom, who's not Muslim, that's totally fine. Granted, obviously, that technically that mom's right arises today. It doesn't arise at your death, but their rights over the property start today then. If you gave it as a gift, that right starts. That being said, what's commonly done is a elderly woman, for example, will gift the jewelry to her daughters while she's still living, because she wants to make sure it gets distributed the way that she envisioned for her daughters, for example. But at the same time, if she wants to continue using it, she needs the permission of the daughters. So again, in a typical family, that not an issue. We're following the Islamic provision of gifting during life and using it with their permission. Now, there's a couple of kind of famous different opinions on this exact topic of, well, what if I'm, I converted, I'm a Muslim, my entire family is non-Muslim, I haven't married another Muslim person, I don't have any Muslim children. In that scenario, am I allowed to give to my non-Muslim family because there's no one else to give to? Now, I don't know if you guys have heard Sheikh Yasir Qadhi, who's a very, very well-regarded, well-known scholar, probably one of the most famous and popular, I guess, in the Western world, because he's kind of well-educated on both fronts. So he cites various other scholars to say that in that particular scenario, because we don't live in an Islamic state where we have that Islamic hierarchy of who can receive in the hierarchical system, you're allowed to utilize non-Muslim heirs in that particular scenario. So in Islamic countries, the difference is that when you go through the hierarchy of who receives, right? So immediate family, more extended family, and there's a default end destination of the Islamic treasury. So again, I didn't want to get too deep into that kind of conversation because it's a black hole in some ways because it's not relevant to us in today's age. But we don't have that kind of Islamic treasury here in the U.S. So instead of that, because we don't have that default provision or way of passing on our money, we're authorized or allowed to give it to our non-Muslim family if we don't have a Muslim family. Once you have a Muslim family, then that general rule kicks into place. Other scholars, though, I want to note, have said there's no exceptions to this rule, even for people in in the United States or elsewhere. So again, I implore you to do your own research on this point if it's a concern of yours. I have the link here for Yasir Qadhi, but in case you want to do it, you can just Google Yasir Qadhi inheritance, non-Muslim, Muslim, and you should be able to find his exact, it's about a 15-minute video. But anyways, I know that's probably a topic of concern for you guys. Asrar, I'll hand the mic back to you. If you guys have any questions, this is our website. This is our contact us email address. We're happy to chat. We're happy to talk through anything that you guys have in terms of questions. You know, we're honored and humbled to be here with you. Thank you so much for listening. And if there's any questions, Asrar, you're free to let us know.
Oh, I'm talking on mute over here. Jazakallah khair to Amro and Furqan for the wonderful presentation. I know that Islamic inheritance and for those who went to law school wasn't exactly the most exciting topic. Just inheritance in general is very draconian, and and just, it seems like you're talking from Old English, and a lot of it's like imported from from England. So so for the language is foreign to us, even though it's English. But yeah, the topics are complicated and they're dry, and so that's why a lot of people sometimes even avoid dealing with it until it's time to deal with it. I think that's now a good time to open up for questions and answers. We have about half an hour and we run into Maghrib time. So are there questions that people have, or I can fire some away on my own if just to kind of get the ball rolling? How about this? I will ask a question. If somebody else from the audience has a question, you could message me privately on the Zoom chat, and I can ask it on your behalf. But to get things started, so kind of one of the things that I was thinking about as you were talking about this is that what if you have a child that's special needs, and so you may have a daughter, who is perhaps has some condition where she's going to need additional resources from you, and if you pass, you want to make sure that she's specially taken care of, and your son is healthy. Are there any Islamic exceptions where you could allocate more for the special needs child in the instance where she was going to receive less on a standard note?
Sure, Amro, you want to take that one, or should I?
I could take it from the secular side. I'm not aware of any exception under Islamic law that would allow us to give more money through the inheritance. The only thing I could think of is for probably what you were going to suggest is doing something during your lifetime to set something up.
Yeah, from the secular side, obviously not too many complications there. You can set up special needs trusts. You can set up different ways to distribute or take care of the special needs son or daughter, and without affecting their government benefits. So that's a very common way of doing special. It's what's called a special needs trust. It exists for that particular purpose, that we want to make sure somebody's not losing their valuable government benefits because healthcare is too expensive in this country, but at the same time, we don't want to have their rights or their shares, even under the secular system, disregarded. From the Islamic side, it's actually very interesting because Yasir Qadhi, I mentioned him again, but he actually did a talk, I want to say last week, on this particular issue of, does this person, if it's a special needs son or daughter, does he or she even get an Islamic share? So that was kind of the question people were asking, that he or she can't manage that money themselves. Do we still have to prescribe a share for them? From the Islamic side, the answer was absolutely yes, but at the same time, you have a situation where somebody else can be designated upon the agreement of the family to manage the assets for that person and utilize those funds for the benefit of that person. So Islamically, you can give, if this is a concern of yours today in life, then there's nothing that should be stopping you from setting up some of the provisions right now while you're still living and able to manage. But upon your passing, there's no exception, like Amro said, that I know of either, that automatically provides them more.
I think you're on mute.
Yep, you just
Got
muted
it.
yourself,
Yep.
sir.
Right. Jazakallah khair for the answer. One of the questions that came in is that we touched upon at the end about people without families, but can we go into a little bit more detail about what considerations does somebody take that's that the person is completely single and has no heirs, and what if her potential heirs are a different country? So if we take like a single person living in America, or a person with their heirs in a different country, like they have their children back in India or something like that. How do we broach those situations?
So from both the secular and Islamic perspective, a person abroad isn't disinherited by the fact of their distance. So they're still technically entitled to shares. Now, obviously, if you can't find that person, that raises a complication. Are they still alive? Are they around? Uh, in the Islamic system, at least, obviously, and in the secular system as well, it kind of works similar in the sense that your immediate family is the rightful heirs, and it goes further and further down the chain until you find the closest family that's alive. So sometimes you'll hear these crazy news pieces about so and so who received 20 million. Somebody tracked him down because he's the only surviving heir of this really, really rich person who was out there. So you'll kind of hear some of these news here and there, but in both situations, if you're single, we still have a distribution system. You might have to go further down depending on your family situation. Ultimately, if we talked about that last slide, if you have no Muslim family, there's no one around, literally no one around to inherit, you can give it to the non-Muslim family if you prescribe to one rule. If you don't, it's just, I don't know what the answer is otherwise, because the other scholars just say that you can't give it to the non-Muslim people. Presumably, I guess charity or mosques, but it's a gray area.
Thank you. The next question is interesting. It reminds me of a law school question, so it should be fun.
Oh, so fun.
I finally get to ask it instead of answer it. But the question is, can you leave money, leave a wasiya in a trust to a non-Muslim parent, subject to the exception that they receive it only if they accept Islam, and if they don't accept Islam, then it goes to most of the original heirs?
Amr, you want to take that one?
No. I'll say it's a good question. It's been litigated. It has been litigated, and I am familiar with I guess not that familiar, but pretty sure it's a New York case where somebody left something to his daughter only if she were to marry a Jewish person, and that was upheld. So that would make me think that yes, this should be allowed, but that was an older case too, and times are changing. So we can't promise it, but I will say something. A lot of times with your wishes, there are going to be gray areas anyway. And if that's the closest you can get to what you want, maybe that's what you try to draft. And you could work with your attorney who you can pay to do the research and draft it in such a way so that maybe, hey, if this is deemed to be held unenforceable, then the money goes to wherever cause you would want it to go if a court were to deem it unenforceable. And if a court were to deem it enforceable, then it gets enforced. So you can get your wishes met, even if you're not, regardless of what the law is. Like if you knew the law was one way, you would do one trust. If you knew the law was another way, you'd do another trust. You can actually do both trusts and tell the court or tell your trustee, this goes to courts, whatever the law is. If the law is this way, distribute the assets this way. If the law is that way, distribute the assets that way. Does that answer the question?
Yeah, that was helpful. Jazakallah khair for that.
No problem.
One of the questions is, what is a surrogate form?
You mean like a healthcare agent form?
Yeah.
Oh, yeah. They call them different things in different states. I will say Illinois has a default surrogacy act where a spouse could, without the existence of a healthcare agent form, make decisions the for someone who's unable to make decisions for themselves. But what I think the questioner is asking about is the healthcare power of attorney, which they can actually Google online, and you would get the Illinois statutory form that you can download and fill out. Though I'm not providing any legal advice, you can look. They do have like a Q&A explaining what the form does, and that's probably what the questioner is looking for. So again, just you can Google healthcare power of attorney. Illinois has a Q&A at the beginning of the form that helps you understand what it does. And you can name whoever you want to take care of you, help make healthcare decisions on your behalf. If you don't want to be your spouse first, you can name a brother first. You could do it however you like.
That same questioner asked if this is something that we can help with at our firm to figure out how to complete that and the implications of it.
Yeah, well, one thing I want to say is we're not soliciting any sort of business on that side. We obviously want to help whoever we can help, and I want to say I think 100% of estate planning attorneys I come across are capable of helping with that. And specifically, if people don't want to pay, there's obviously always a benefit to having a lawyer. But Illinois did make the form so accessible online so that people aren't paying attorneys to help them with powers of attorney forms if they feel like they understand the form themselves.
And I was going to say, I'm a big proponent of self-help as well. So one website I always recommend to even my own clients is Nolo, Nolo. So Nolo is kind of like a self-help. There's a couple of these types, but the two most common I think are Nolo, Nolo, and then there's Illinois Legal Aid Online, ILAO. Both of those are great resources written by great attorneys who provide answer a lot of questions relating to some of the basics. Obviously, they'll also be the same, they'll have that same kind of disclaimer that this isn't legal advice. At the same token, it's a great way to kind of get knowledgeable about some of these different forms that Illinois has, some of the different benefits and features of what you can do yourself even before you even get to a lawyer's office. So definitely worth checking out. It might answer a lot of the questions you have. Again, every case is different, so it may or may not suffice for your needs, but at the same time, it's good education.
Now, I do want to say, I'm looking at the list as well. We can comfortably say we're happy to help to the extent we can. So don't hesitate to contact us with any questions. I don't want to dismiss that portion. Just want to make it clear that it may not be necessary that you end up retaining a lawyer. And if anyone here has any questions regarding these things, send us an email and we're happy to help.
Great, thank you for that. One of the other questions that came about, I think it relates to what we asked earlier about disabled child, but it's about is there a provision under Islamic inheritance law to give an unmarried adult sister who's mentally challenged, I guess, part of your assets after you die? And if so, what's the method to have her receive the asset after you die?
So, I mean, we have that wasiya 1/3. So the sister is a perfect example in that scenario. If let's say you have a special needs sister, you could designate up to 1/3 of the Islamic estates for her, and then the remainder you'd still have to utilize the Islamic distribution scheme, but you could leave that 1/3 for that sister, and that'd be completely permissible.
Perfect. Thank you for that. And what about I call this the elephant in the room question, but typically people who are we're focusing this on the converts and reverts, but is there a reason why women don't get as much under Islamic inheritance law? What is the obvious wisdom behind that?
It's a great question. We actually get that question asked of us often, both from Muslims as well as non-Muslims. Sometimes in a very genuine, we want to know what the rationale is, and sometimes it's more implicitly implying something. So we do get that question a lot. Me personally, and it took a lot of research for me to kind of get to my own conclusion on that point, which is that we don't, in our Western way of thinking, we don't always understand some of the beauty behind the Islamic rules and rationales. So when you read about why this system exists to begin with, the 2-to-1 kind of ratio, you'll note that parents, for example, are 1/6 each, right? So there's no difference between, in that scenario, like a mom and a dad. But when you get to the kids, why do they have the 2-to-1 ratio? And I think the reason is, and again, this is just from my understanding of it, that the obligations and responsibilities provided or given to the son are different than what's given to the daughter. So for example, if a daughter gets 25,000, right? Let's say 2-to-1, son gets 50,000, daughter gets 25,000. If the daughter goes and buys a brand new car, no one is allowed to really question that or say it's her money. She can do what she wants with it, right? Granted, it's within the Islamic kind of parameters. You're not gambling it away or something, but the daughter has the right to use it as her money. The son does not have that same right. So if he goes and says, I want to buy a $50,000 car, technically his obligation and the reason he gets more is because he needs to ensure that the family's needs are met. So Islam puts in a place of responsibilities on the males in this particular scenario that's different than the female. So if I'm the son and I get 50,000, I can't just go out and spend it. In contrast, if somebody in my family needs money, I'm obligated as receiving the 50,000 to actually use my portion of the inheritance to help that person in the family. So obviously you can see how there's kind of a little bit of a conflict almost from the Western perspective as well as the Islamic, but that's the rationale and that's why we kind of, how we understand it. Now, there's a couple other components of it. When we talk about Islamic obligations, sometimes we're able to understand the beauty and the rationale behind it. Sometimes it doesn't always register 100%. And the reality is, there's rules in place that we follow. Like for example, no one's going to argue that Islam doesn't say that we can't gamble, right? Or we can't drink alcohol or buy alcohol with our money. No one really questions that, right? So from some perspective, Islam has these rules with how we spend our money, how we can earn our money, and how we can give it away. So it all kind of falls within the same parameter of how Islam deems, assets and how they can be used, our earnings, how they can be used and how they can be distributed. So I know I kind of delved into a stream of thought, but I hope that kind of drives the point home a bit.
Yeah, that was really a really good explanation. Another question that came in, and this is I didn't know if I should bring it up or if I should wait for a questioner to bring it up, but the 4 wives question. So if a man has more than one wife, is he allowed to draft a will to particularly accommodate for that circumstance? Will the American courts have to uphold it in the way that it was intended, considering that obviously they don't allow for legal spouses and like registered spouses?
Yeah, this is an example where public policy would, the secular public policy would outweigh any other considerations. So at a preliminary step, if a court were to ever see a will that has provisions for 4 wives, it would automatically be stricken down because by law, that's something that's not permissible in this country. So from a very basic secular perspective, that wouldn't be upheld.
Okay, great. The other question then is, and this is kind of a cautionary, question too, but suppose a person has no will, nothing prepared. The default is that American law will apply to any person that's in America, right?
Correct, and it's further complicated a little bit by the fact that people think, well, why don't I just write on a piece of paper that I want my assets to pass in pursuant to Islamic law? Why can't I just write that on a piece of paper, have a notary and a witness, and bam, we have our will, right? The problem is secular courts don't interpret Islamic law. So it's a misconception or misnomer to say I can just designate quote unquote Islamic law as what's going to govern my asset distribution But if a court sees that, it's automatically stricken because secular courts will not be put, they don't want to be put in a position where they have to interpret religious laws.
Got it. Okay. And Fran, how does it work in a situation where suppose you have, well, this is a two-part question. The first part is suppose there's family members like a nephew or a niece that you want to take care of.
Mm-hmm.
Number one, would this go through the wasiya portion of your
Provided they're not the closest living Islamic heir at the time of your passing, then yes, the wasiya would be the best way to care for that person.
Okay, then I think this is because people haven't experienced this yet. But when you draft a will, suppose you have a will and it doesn't even go through lawyers, and you don't assign like an executor or a trustee for the assets. What happens? So suppose the kids are minor, the nephew and niece, and so you assign some money to them. Does a court just appoint somebody, or what happens in that situation?
Will you want to
Want me
take
to
that
take
one?
this?
Yeah, sure.
Yeah, if somebody's a minor when you pass away, it goes to that minor's guardians, which is usually the parents, if you're naming a niece or nephew. But if they don't have parents, then a guardian would have been appointed even before you passed away. Now, if you're leaving, and depends on the state, I believe Illinois is $10,000. More than that, they actually have to open a separate probate estate on behalf of each minor child, and the court oversees that distribution to make sure that the guardian doesn't steal the money from the child.
Is accounting required on that?
Say that?
Is there accounting required on that?
An annual accounting is required, and then usually approval during the year if you want to make expenditures.
Yeah, okay.
So a better way to leave money, and I know it's more complicated or more expensive, I should say, is to put it into a trust. So you create a trust for the niece or nephew, and you appoint who you want to be the trustee of that trust, so that when you pass away, the trustee will have the funds. The trustee can essentially have free reign to do what they want as long as it's for the benefit of those children. That way your sister doesn't have to go to court every year, or your whatever the guardians that have to, if you trust the guardian.
Okay, great. Thank you for that. Next question is, and this is I think someone came a little bit late, but they wanted to reiterate something that they caught was that if they don't have any Muslim family, the convert doesn't have any Muslim family, they're concerned that they can't leave any money to their non-Muslim family. I think there's more like it seems to be they have a concern with like is that the I know you said there's a difference of opinion there, but can you go over that again a little bit?
Sorry, repeat the question. I was a little.
Oh yeah, no. The question is, if I don't single person who has a non-Muslim family, I think she caught the fact that she couldn't leave money to them. She came a little bit late, she said, so she caught the fact that.
Okay.
So can you kind of go over that again?
Yeah, so there's a difference of opinion, but essentially I pulled up two of the prevailing positions, one being from Sheikh Yasir Qadi, who is a well-known Western kind of educated Islamic scholar, and then kind of like the other general opinion that exists in that particular circumstance. So as a general rule, there's that hadith that says a Muslim shall not inherit from a non-Muslim, and a non-Muslim should not or shall not inherit from a Muslim. So we have kind of this provision that if you have non-Muslim family and they're technically somebody who falls under an Islamic heir, right, like i.e. a spouse or children or a parent, technically under the Islamic rules of inheritance, that person would not stand to gain. Now, there's a couple of vastly agreed upon principles, one being that wasiya provision of the 1/3, that can be used for non-Muslims. So you can give up to 1/3 even to a non-Muslim person because that's your right under the shares. Or you can give gifts during life. So those are the two easy kind of exceptions or workarounds, so to speak. Once you get through those two exceptions, then there's that split of opinion as to whether that non-Muslim person can or cannot inherit. So the general, one of the rules is, or one of the opinions is that if in your particular circumstance, there's no one else that's Muslim, all you have are non-Muslim relatives, non-Muslim parents, etc., But if that's all you have, then that hadith doesn't apply to you, because we don't live in a Muslim country. We don't have an Islamic treasury that would otherwise be the default place to park all the money that doesn't go to Islamic heirs. Because that kind of system doesn't exist in today's society here, you're allowed to give it to non-Muslims under even, and that's permissible. Obviously, the other side of that opinion, there's, the other opinion on that is that, there is no exception to that rule. If you don't have, any Muslim relatives, any Muslim heirs, you need to kind of figure out where it could go, but it can't go to them outside of the wasiya and outside of the present day gifts. So that, if that is the opinion, you should read into those two opinions that I think I had on the slide, and we can circulate the slide, so hopefully that will help. But that had the link. You can also Google, that kind of question and find Yasser Qadhi's piece on it where he discusses it, as well as other scholars.
I think we have time for probably one more question, then we run the Maghrib time. This question comes from a personal experience I came across in my practice, and that is, suppose you have a revert brother or sister who has a family and Muslim family, and they have a child, and the parents pass away, and the only people left behind are the non-Muslim family that are closest kin to the Muslim child, and the revert family, parents are afraid that if this child goes back to their non-Muslim family, that they may be raised as a non-Muslim, and they assign somebody who's not as close as maybe their grandparents to take care of the child. Can the non-Muslim family overturn that wish of the parents that that the child not be with a non-Muslim family and instead go to a family that is Muslim?
That's a great question, and I think both the secular and Islamic principles would align on this question. So on the Islamic side, I think it would probably, again, you'd have to talk to a scholar, but I think it's certainly very reasonable to have the child go to whomever you trust that's going to raise the child in the best environment from an Islamic perspective. On the same token, on the secular side, even though there might be people closer of kin to you, that doesn't automatically designate them to be de facto guardians of the child if something were to happen to you. So it's not like the grandparents can petition saying that they left these kids to so-and-so, and we are closer, therefore we're entitled to the kids. It's not how it works. As long as the guardian you designate is fit to be a guardian and capable and able, it's going to be very, very difficult for a family to, or let's say grandparents, to overturn your desires and your wish. But obviously the big question is, if you don't have that in a will or some kind of guardianship form, there's no way for you to state your preferences. So all else being equal, if you don't have your wishes stated, then the court has to decide, without your wishes being known, who should take over the responsibilities of the child. And usually the faith is not something the court wants to put too much precedence on. It might be one factor, but at the end of the day, it usually tends to defer to whomever is the next closest of kin.
Excellent. Jazakallah khair for that. And I think that probably takes us to the end of our presentation and question and answer. I just want to say Jazakallah khair to, first of all, GainPeace for allowing us to partake in this event. I mean, it feels very honored, and I felt like this was, really good, moment for me to even brush up on some of my estate planning skills and to learn from Furqan and Amro. So Jazakallah khair to both of you, and to Brother Sabil for putting this together, and all the organizers of the event. We'd like to thank you for giving us the opportunity to present here today. And if there's no other closing remarks, I don't know if the organizers want to take it from here, and we can conclude our program. Okay, looks like inshallah we'll be concluding it from our end. Jazakallah khair, everybody, for attending, and inshallah we look forward to hearing from you. Any questions you have, please feel free to just chat with us about it. We'd love to be of help to all of you, inshallah. And maybe we can get this slide set over to Brother Sabil so you can share it and disseminate it amongst all of you. And our contact information is on the last slide. So we look forward to hearing from you, inshallah. Jazakallah khair, everybody. Assalamu alaikum.
Thank you so much.
Alaikum salam.
Waalaikum salam.